Welcome to OurSeniors Radio, a nonprofit dedicated to honoring our seniors by providing relevant information on senior needs. From health, wellness, and lifestyle to residential, medical, and legal, just to name a few. Our seniors and their families are able to make educated decisions and live their best life. Find them online at OurSeniors.org as well. And yes, you can become one of our seniors. Welcome aboard.
Hey everyone, welcome to OurSeniors Radio. Thank you for joining us. And as a reminder, if you missed the show, which is Saturdays at 8 a.m., please don't hesitate. You can watch and listen to the shows on OurSeniors.net. Okay, we have all of our previous shows on there. And you can go to YouTube to our channel, subscribe, and you can watch the entire videos and listen to the entire shows there as well. Okay, feel free to do so. We want to remind everyone that we're having some fundraisers at Red Robin. The ones coming up in March, okay, will be March 20th at the Red Robin in Sanford, and March 27th, the one in Port Orange. All you have to do is go to eat there anytime during the day, mention that you're there to support our seniors, and Red Robin is doing a great job. They're actually donating 20%, okay? So we really need your support. We highly encourage you to make it there. And by the way, if I missed out earlier, my name is Julian Cantillo. I'm the president and founder of the OurSeniors family. And we're excited because every week we bring new shows to the seniors, okay? And please take a look. We've done specials on seniors versus crime with the special program with the Attorney General's office, you name it. The City of Ormond Beach Police, Volusia County Sheriffs. Stay on top of what's going on, and also medical related guest speakers, okay, so that you can stay informed, all righty? And the other plug that we need to bring to your attention is we're also having a lunch and learn at Red Robin, okay, March the 27th. By the time you hear the show, you'll still have time to register. You can call 386-516-3969, extension 4, and we're going to have Ann Hardick from Dignity Memorial doing a presentation, and they can help you with a planning guide, etc. And yes, the best part of everything is that it's El Fribo, lunch and learn, okay? So come on down, Red Robin, yummy for the tummy, okay? And we're excited this morning because we're going to be talking about a very delicate topic that everybody needs to be prepared for. Okay, and with us this morning is one of our approved vendors. We have the honor and privilege of having with us Mr. Andrew Grant. Welcome, sir.
Thank you. Good morning.
All righty, and Andrew, we've known Andrew for quite a few years. Andrew, give us a little background on where you went to school, where you're from. Give us a little background, please.
Sure. I'm an attorney. I've been practicing here in the Ormond, Volusia, Flagler area for 23 years now. I've been a licensed lawyer for about 26 years. I grew up in Wisconsin. I went to college in Missouri. I got my law degree in Illinois, and then I came down here to Florida and got my Master of Laws in Taxation at University of Florida. And after that, we just stayed here in Florida. It's been a transition from the north to the south, but we like it here.
It's a little warmer, right?
A little warmer, a little more humid, yeah, just a little bit.
Excellent. And Andrew, give us regarding a little background on the firm that you're with, where you have locations, etc.
Sure. I work with Shimento Law. They are in their 50th year as a law firm in the Flagler-Volusia area. There's offices in Palm Coast and Ormond Beach. I work primarily out of the Ormond Beach office. It's a full-service firm. We do all kinds of things. I do estate planning. I do tax law, business law. But we also have probate, we have guardianships, we have real property, we have personal injury is a big one, and we do some family law, divorce, that kind of thing.
Excellent. And tell us again, you have an office in Ormond Beach, right by Granada?
Right, we're on Granada. We're just a little bit west of the Granada Bridge. It's one nice little office. Parking is not great, but it's a good, nice location. It's a good place. The Palm Coast office is the main one. It's up in City Center, up by the high school up there, if you're familiar with that area, just off of 100.
Okay, excellent. Excellent. And with respect to, everybody usually goes through this, and especially if you lived in another state and all of a sudden you relocated, you had a will, you had a trust, generally speaking, and this is just general, we'll get into more specifics here in a moment, but let's say I did a will, I came from Ohio, relocated, now we're here and we're concerned whether the will or trust is current, up to date, does it meet Florida standards? How does that work normally?
That's a good question, because as we all know, there's not a whole lot of Floridians who are actually born in Florida. So a lot of them come to Florida with their documents already in place from another state. Generally speaking, documents are good in Florida if they were good where you had them drafted. There's some exceptions. For instance, some states let you just do a will which is handwritten and not witnessed. Florida does not allow that. You have to have two witnesses. You can handwrite your will, but you have to have two witnesses to sign the document to make it an official will. But otherwise, usually those documents will work. We recommend you still have them updated to Florida, just because Florida's laws are a little more quirky than other states, which is no big surprise to anyone. But yeah, generally they work. If you had to rely on them, you should be able to rely on them.
Excellent, excellent. And boy, we have a lot of questions here for Andrew. So we'll take a little break and we'll be right back.
Care Plus Health Plans cares about your health. That's why their Medicare Advantage plans include $0 copay for primary care visits and access to providers in their trusted provider network, like Dr. Stephen Quanning. Metro Health of Holly Hill is now open at 1852 Ridgewood Avenue in Holly Hill. With in-network providers like Dr. Stephen Quanning, who strive to provide quality care for patients, Care Plus helps connect members to the care they deserve. You can schedule a tour of Metro Health of Holly Hill Center today. Call 386-463-0522 for more information. For more information on how you can find a plan connecting you to the care you need, call a licensed Care Plus sales agent at 855-569-4558, TTY 711 to learn more. Atlantic Coast. Provider may also contract with other Plan/Part D sponsors. Other providers are available in our network.
Hey everyone, welcome back to OurSeniors Radio. And again, reminder that we have our guest here today with us, Andrew Grant, an attorney that has a pretty extensive background, but we're focusing this particular radio show on wills, trust, you name it. So give us an idea, Andrew. What is estate planning?
Estate planning is planning ahead for what happens when you die, as well as what happens when you can't take care of yourself anymore. So essentially, it's planning for the worst, because everyone at some point will die, and it's important to have documents in place that say what happens to your stuff when you die, who is in charge of making decisions for you after you've had your final arrangements, if you haven't taken care of that yourself, and basically making sure that your wishes are carried out. And on the other side of it, what happens before you die, if you become disabled, and hopefully, you live long enough to not get to that point, but just in case, because it does happen, you become unable to make decisions for yourself, either medically or financially, and it's important to have documents in place that let someone you trust take care of those things for you, and not have to go through the whole hassle and expense of going through a guardianship.
Excellent, excellent. And now that you brought that up, I just want to remind our audience, and obviously you can answer this question as well, pertaining to whether you're married, single, whatever the case may be, even for kids over 18, it reminded me the healthcare surrogate. Mm-hmm. When you have any issues that you can't make decisions for yourself, explain, because this is extremely important that everybody has at least one healthcare surrogate assigned. Go ahead.
Correct. It's the designation of healthcare surrogate is the form we use. That's what Florida calls it. Some states call it a healthcare power of attorney, but it's all basically the same thing. It gives someone the authority to make medical decisions for you, to get access to your medical information from your doctors, and to decide what is best for your care when you can't do it for yourself. And it's important for everyone to have this, because even though you say you have an adult child and they're not married, if you don't have a healthcare surrogate power over them, then it's quite possible the doctors are not going to listen to you. Without that healthcare surrogate, they're going to do what they think is best for your care, for the child's care. Even though you're the parent, even though you should be able to make these decisions for your child, if they're an adult, you don't have the legal authority without that form.
And this is extremely important, and I think you've mentioned it before, that just because you assign someone as a healthcare surrogate doesn't mean you can't remove them later on or at any time, correct?
Well, exactly. As long as you are able to make decisions for yourself, you can always revoke the power of the healthcare surrogate. You can always overrule them, as long as you can make your voice heard. The surrogate is mostly there for when you can't make your own voice heard.
Okay, and I just want to make sure everybody's aware we had this situation firsthand, and it may not be a bad idea to assign 2 healthcare surrogates and always have a backup. In other words, they're both healthcare surrogates, but what happens or could happen is the hospital reaches out to one, they're not available, they're not responding, they're on vacation. Guess what? If you have a second one, they can step in and make decisions for you.
Exactly.
This is extremely important. And this is a good time to take a little break, and we'll be right back.
OurSeniors.net provides reliable and accurate information to serve the seniors of Florida. No matter what kind of assistance you need, from home repair to finances to buying or selling a home or considering assisted living, our team is here to help you. Our carefully chosen vendors meet our exceptionally high standards and adhere to the OurSeniors.net Code of Ethics. Want a magazine in your hands? Visit OurSeniors.net or call 386-516-3969.
Hey everyone, welcome back. And I'm so glad we have this great guest with us here today, because there's always a lot of questions and confusion, and you really have to decide which is the best direction, and you really need to consult an expert. Do I do a will? Do I do a trust? And with all the online situations out there right now, oh yeah, you can do this online, just click here. So Andrew, tell us, do we need a will, a trust? What's applicable here?
For the vast majority of people, a will is probably sufficient. A trust is for avoiding probate for larger estates, or when there's certain special circumstances, like you need a trust set up for one of your children because they're not good with money, you don't trust their spouse, they're a minor, that kind of thing. A will still cover everything you need to do as far as what happens to your possessions when you pass. The only difference is that a will, anything going through by will, passes through a probate proceeding, which can be long and complicated, especially if there's a fight among your beneficiaries. But if everything is straightforward, all the kids get their equal shares, they're all happy with that, a will is perfectly fine. The will also can pass your personal property, so like your cars, your boats, your other toys like that, can pass without probate. You just take the will and the death certificate down to the DMV, anything that has a title like that, and they'll just transfer title with just seeing the copy of the will. No probate necessary. So for most people, that's going to be sufficient. And there's other ways of avoiding probate also. Like for bank accounts, you can make them pay on death to your beneficiaries. Retirement accounts, of course, have beneficiaries to them. Life insurance has beneficiaries. If you have an investment account, you can make that a transfer on death, designation to your children. So all of that avoids probate. There's lots of ways to avoid it without going through the expense and complication of a trust. That said, for people with larger estates or sometimes long-term married couples with investment assets that are going to be subject to, large capital gains because they bought them a long time ago, trusts can be very useful. Florida created what's called a community property trust recently, and that turns any property you put into that. Two spouses make the trust. You put the property into it, it becomes community property for tax purposes. There's certain trade-offs, but the main benefit is that for federal tax law, community property at the first spouse's death gets a full step up in basis, meaning there's no capital gains to be paid by the surviving spouse. Otherwise, with joint property, there's only a 1/2 step up in basis. So there's still some gain there to pay taxes on when they sell the assets. Now, the trade-off is that community property is considered owned equally by both spouses. So in the event of a divorce, it doesn't matter who bought the property with what money, it's going to get split 50-50 unless you agree otherwise. That's the main trade-off on that one. But otherwise, a revocable trust is useful for, like I said, planning for complicated situations in the family, or for larger estates where you have property outside of Florida. You want that property inside a trust so you don't do probate in Florida and outside of Florida, which can be a major hassle and expense.
Excellent point there. And as an example, who should we name as a personal representative and/or trustee?
Well, for married couples, it's typically each other first. And then if they have children, you'd put one or more of the kids on there as the backups. Sometimes you don't have that, though. Sometimes it's an older couple, they only have each other. So in that case, you're looking at naming a friend. If it's someone who's not family, they have to be a Florida resident to be the representative under your will, your executor. They can't be living outside of Florida. For a trust, it doesn't matter where they live. You can name anyone. Sometimes people don't even have that, though. They don't have someone they think they can trust, or they only have siblings who are older than them. In that case, you can look to a professional to serve in those capacities. Depending on the size of the estate, there are certain trust companies that are affiliated with banks that'll do it. Sometimes attorneys will do it. I know my law firm will do it. I personally will do it if there's absolutely no one else, because I'd rather have family or friends take care of this, because they know you, they know what you want, they know your beneficiaries better than I do. But as a last gasp circumstance, I will serve as that. Most attorneys will do that as well if they practice in this area.
Excellent, excellent. And if you do choose a personal representative or a trustee, can you revoke that at any time?
Absolutely. It's not irrevocable until you're gone. So you can always change your will, you can change your trust. Generally, even if you do what's called an irrevocable trust, you can usually change the trustee on that too. The grantor retains certain powers. But yeah, as long as you are capable of making decisions for yourself, you can always change your will on your trusted whenever you want to.
Excellent, excellent. Wow, there's so much information, and we have a lot more questions for Andrew. We'll be right back.
Did you know that Metro Health clinics are dedicated primary care clinics for seniors? Metro Health treats senior patients with state-of-the-art technology and old-fashioned listen to the patient understanding. Call us now for a no-obligation tour. Interview our staff, ask questions, and learn more about Metro Health's team by calling 386-467-4430. We love and support OurSeniors Radio and Magazine. Yes, you can become one of our seniors.
Hey, welcome back, everyone. And again, we have our guest, Andrew Grant, attorney Andrew Grant. And Andrew, people move here to Florida from all the different states, etc. Even if you reside here, you have the Florida homestead that everybody's familiar with that, especially if you just have it on a primary home. Mm-hmm. So is it owned by the trust, or Will, how does that work when something like that is on there?
Well, your Florida homestead is a rather unique creature in law. There's three different kinds of homestead. There's, of course, the property tax homestead that everyone's familiar with. There is also then the homestead segment that is protected from creditors. Your homestead cannot be seized by your creditors unless it's the bank you borrowed money from to buy it, a contractor that did work that didn't get paid, or the IRS, because the IRS can get whatever they want. Generally they don't, but we won't get into that right now. Then there's the homestead with this restriction on who can own it upon your death. So if you're a married couple and only one spouse owns the homestead, that spouse can only leave the homestead to the other spouse, the surviving spouse. If you try to do anything else, it's not a permissible devise or gift. The surviving spouse then either can take a 1/2 interest in the homestead or has a life estate in it. And then the kids get the remainder of it. Now, in terms of whether a homestead should be owned by a trust or not, there's different schools of thought on this. I prefer not to, because the homestead, again, because of the creditor protection, is not a probate asset. It's not subject to your creditors in probate when you die. So even if you were in a nursing home and racked up huge debts from that, they can't come in and make your children sell that house to pay those debts, because it is a protected asset from your creditors. Now, because in Volusia and Flagler counties, you still have to get what's called the homestead order to make sure you get that protection. To get that homestead order, you have to go through the probate court. Typically, it's just a summary probate at that point if the homestead is the only major asset. And they go through the summary probate, which is a fairly short, relatively inexpensive proceeding. And once they have that homestead order, then it is sealed that the creditors cannot come after it. So it's protected.
Gotcha. Unless, obviously, it's the bank itself that you still are paying a mortgage on,
right,
et cetera. Okay. And just briefly touch on it, because it may be a topic that we may have to address another time, but that term that's used out there, ladybird, what exactly is that?
A ladybird deed is a way of transferring real property to a beneficiary without going through a probate process when you die. So basically, you sign this deed, which reserves what's called a life estate to yourself. It's an enhanced life estate, so you can do whatever you want to with the property. You can sell it, you can mortgage it, without having your beneficiaries approve that. And then upon your death, it automatically transfers to the beneficiary. Now, there's different schools of thought, again, on this and whether that works for a homestead or not. I don't like to do it because there's issues potentially with the title, with your beneficiaries owning it that way. Homesteads, like I said, it's not a probate asset, so just let the will take care of that. It works great for investment properties, a vacation home. So if you have a condo down in Boca that you want to give to the kids, a ladybird deed works great for that, but I don't like to use it for homesteads.
Gotcha. And that's a good point. And we'll probably have you back on the show here soon and ask you even more details about this. But we have a few more questions, so we'll be right back.
Care Plus Health Plans cares about your health. That's why their Medicare Advantage plans include $0 copay for primary care visits and access to providers in their trusted provider network, like Dr. Stephen Quanning. Metro Health of Holly Hill is now open at 1852 Ridgewood Avenue in Holly Hill. With in-network providers like Dr. Stephen Quanning, who strive to provide quality care for patients, Care Plus helps connect members to the care they deserve. You can schedule a tour of Metro Health of Holly Hill Center today. Call 386-463-0522 for more information. For more information on how you can find a plan connecting you to the care you need, call a licensed Care Plus sales agent at 855-569-4558, TTY 711 to learn more. Atlantic Coast. Provider may also contract with other Plan/Part D sponsors. Other providers are available in our network.
Hey, welcome everyone. Welcome back. And again, our guest is Andrew Grant, attorney Andrew Grant. And we were talking about wills, trusts. I mean, we've talked a little bit about everything, but what about something happens? Does the beneficiary at the time of your death, do they pay taxes on any of the inheritance?
Generally speaking, no. If your estate is large enough that you're going to owe federal estate taxes, then your estate has to pay the taxes. So there's tax on that. Right now, that's $13.6 million per person. That's going to get cut down in 2026. Not sure what the number is going to be. Figure around $7 million. If you've got more than $7 million, it's going to be estate tax on that. That's per person. So it's $14 million per couple, per married couple. And if you've got that kind of money, there's other money we can do. Please call me and we'll try to figure that out for you. But if you're less than that, there's not going to be any estate tax on that. And as far as income tax goes, there's no capital gains taxes on anything that your children get from you at your death, because you get that step up in basis. So even if you bought, Apple stock at $5 a share, they get a step up in basis to whatever it's worth now. So they don't pay any capital gains on it when they sell it. Certain other assets that they receive from you, yes, there's going to be tax on it, like retirement accounts, retirement benefits. If you didn't pay tax on it during your lifetime and it was income to you, your kids will pay tax on it when they take it out. from your IRA, from your 401k, whatever you have when you pass, and you leave it to them. There will be income tax due at that point. But otherwise, no taxes.
And the children or, the beneficiaries will pay whatever tax bracket they're in, correct?
Correct. So if they get $10,000 of income from your IRA in 1 year, then that adds to their base income from wherever they get, and whatever tax bracket they're at that point, that's the tax rate they pay.
Okay, excellent point. I'm glad you mentioned that. And with respect to, with all these, little gimmicks out there, hey, you can do an online will, you can do this, you can do that, click here. What do you suggest?
Well, of course, as an attorney, I don't like those services much. You get what you pay for, basically. If it's a basic form you get online, it may work, it may not work. It may not have all the nuances that are necessary for carrying out the estate plan the way you want it. Or it may not have the right set of signatures and notary block to be automatically admitted in a probate court. Now, there's other companies out there, I don't want to mention any names, but they say they're designed by lawyers, they're vetted by lawyers. That may be true. And again, they may work, but they're not tailored to what you need specifically. And most people have slightly different needs in their estate plans. Most people are not the same. No generic form is going to cover everyone.
Gotcha. And that brings up the point that if you want to have a sit down, because everybody's case is different, and obviously, you want to protect everybody's information, so you have a consultation, private consultation, husband and wife, whatever the case may be. The number where you can reach Andrew is 386-206-5926, and he's at extension 121, okay? Just to remind everyone, they have offices in Ormond Beach and in Palm Coast. And when you call, if for whatever reason you get a whole bunch of extensions, just dial 0, you'll get the operator and they'll transfer you to his assistant, okay? And give us an overview. So, I haven't done the will, I haven't done the trust, I'm thinking about it. If I call, what happens if I mention Our Seniors?
For people that listen to this show, people that read Our Seniors magazine, if you call and ask for an appointment with me, I will waive the consultation fee. It's a 30-minute consultation. Normally, that's $200. So I'll waive that fee for you. Then we'll sit down, we'll discuss what you need and figure out what the best plan for you is.
That is great news. And folks, you have a living testimony here that all the clients that we've ever referred to Andrew have been extremely happy with the results. Even some folks that were a little skimpy, okay, after it happened, everybody was happy that they did what they did when they did it, okay? And keep an eye out, because Andrew has presentations with us from time to time, lunch and learn events, where he does a complete presentation on wills and estates, and at the same time, he always contributes articles to the magazine on different topics, and the fact that he is tax certified, okay? So you want to make sure you have, and you're dealing with someone who has the right credentials that can lead you in the right direction. Any closing thoughts or anything you want to mention, Andrew, before we leave?
No, I think we covered it. I think it's just a very important topic. People need to make sure that they have an estate plan in place. They need to have basic documents. They should have a will, the healthcare surrogate. They should have a durable power of attorney. And if they want, they should have a living will. Because if you don't want to be hooked up to a machine, if you're at death's door or terminal, the living will is a document that is going to keep that from happening.
Excellent. Yes, because you do need to have all the paperwork in line, folks. And again, this is extremely important. And you feel like reaching out, you can reach them at 386-206-5926. Okay, extension 121. Thank you so much for joining us today.
Thank you for having me. It's been a pleasure.
Thanks for listening to Our Seniors Radio. Don't forget to check out OurSeniors.net magazine and tune in every Saturday at 8 a.m. on WNDB. Help support the nonprofit, which is OurSeniors.org, or call 800-647-0868.